So we haven't discussed Oracle's court battle with Google very much over the past few weeks, partially because so much of it is deja vu. This is kind of a retrial from a case that dates all the way back to 2012. That case ended in an indecisive jury, a hung jury, and then the Supreme Court ultimately ended up passing on the case, and here we are again. So everything feels very familiar, but now it's in the hands of the jury to decide whether Google should have to pay Oracle for its use of Java in the foundation of Android. And joining us to kind of break it all apart is Joe Mullen from Ars Technica, who's been in court following this closely. How's it going, Joe?
Good.
It's great to have you here. Thanks so much for taking time. I know you've had your hands full for the last couple of weeks. You've been covering the case extensively over the past few weeks. You provided some incredibly thorough coverage. First, tell us kind of what's at stake with this case right now.
Sure. Well, I mean, one of the things at stake is potentially up to $9 billion if Oracle wins, which is, not chump change even for Google. But I think it also is a bigger deal in the sense that people are wondering if these kind of cases could happen in the future and what this means for sort of developers, at other companies. So that's something else that's out there.
For sure. Now, how exactly has Oracle framed its case against Google? I know they have it's been a while for them to kind of formulate kind of their approach with Google, and I think there's some similarities, a lot of similarities versus what they did a few years back versus what they're doing now. What is their stance on this right now?
Yeah, so I was actually also covered, I actually started working at Ars Technica around the time of the 2012 case, and I covered that as well. So it's been interesting to see this because I can really compare it. And Oracle has a lot more focused case. I mean, the first time in 2012, they also had a patent case against Google and some sort of other copyright claims that kind of fell by the wayside. So their case is much more focused this time around. And it really just says that, look, APIs are copyrighted. That's copyrighted code. You copied it. You Google copied it. Period. End of story. That's not the right way to build Android, and you got to pay us. It's a lot narrower, and it's a simpler to understand case than what they were doing in 2012, which is sort of saying, we got a whole bunch of IP that came and we bought Java, and Google, we know you did something bad, so we'll sort of throw these different kind of claims at you. In a way, I think because Oracle sort of lost parts of that 2012 case, they actually have a stronger and maybe more dangerous case against Google today. So that's Oracle's position, is just, this is straight up copyright infringement. The fact that it's a small part of Android is just an excuse because these APIs are really, really important. Google's counter to that is, what we were doing was industry standard. Everyone knew the Java language was free and open to use, and everyone thought that Java APIs come with the language, and APIs are application programming interfaces. They're kind of a way that software talks to other software. And so Google has compared them to labels or to menus, sort of saying you can have two different menus that might both have hamburgers on them and they might both have omelets on them, but that's not copyright infringement. That's just a way of letting your customers know what's out there, and you compete on the actual food items. So that's Google's argument, and given that they're making it to an audience of these 10 lay jurors, I think none of whom, all of whom said during jury selection that they had not heard of the terms like open source and fair use. And in that sense, I think Google has a bit of a higher mountain to climb on this case. And the jury is deliberating right now. Today was the first full day of deliberations.
So at its heart, is this, this is sort of is a fair use case. Is this the first time fair use has been argued in a court? Is this one of the first times with software? Not the first time fair use, but
right.
with an API. Like, is this the first or the biggest fair use case when we're talking about an API?
Right. It's unusual for a fair use case of any kind to go to a jury at all. A lot of fair use cases get decided by judges. So I don't know of any other. I also haven't searched. I'm sure if you search, maybe you could find a fair use software case. I doubt you could find another case that's solely about fair use of APIs. We might see that in the future, but really no one thought that you could build a copyright suit just out of using APIs until Oracle did it. And in fact, revisiting the 2012 case, I said, Oracle lost parts of that case. The truth is they lost the whole case completely. It was a clean sweep for Google because the one part that the jury deadlocked on was this fair use issue. And then the judge, after having watched the first trial, said, you know what, these API things, these should not be subject to copyright in the first place. He agreed with basically every point that Google made, that they were functional, that they were kind of a way of organizing information. It was like, like Dewey Decimal System in a library or shelves in a library, and this is not something that copyright was meant to protect. That's exactly what Google wanted, and that would have been the ideal result for them. That judge was overturned on appeal, completely overturned on that point. But the appeals court said, look, this is definitely copyrightable. And Judge Alsup, who's the San Francisco judge who made the original decision, you were wrong about that. But fair use, we don't know. That's a case-by-case basis. So we'll kick it back to you and have a trial over fair use. So that's what we're doing now. And it's pretty nebulous. And I mean, that's why, in a way, this case has been pretty interesting because the jury can kind of do what it wants. I mean, how much use is too much use of an API? It's something that's pretty up in the air. So in a lot of ways, this case has been about lawyers trying to characterize Google in the building of Android, with Oracle pulling out emails that it says indicate Google knew about the fact that APIs were copyrighted, emails that show, Google cares about licensing in other contexts, sort of implying that they blew it off in this case, that they're not playing by the same rules as everyone else. And with Google pulling out evidence saying that, hey, we built Android the right way. And the most powerful thing that Google has in its pocket, I think, in this case, is the fact that Sun, the original owner of the relevant intellectual property here, never objected. This is pretty clear because Sun's ex-CEO, Jonathan Schwartz, was on the stand. Sun never objected to the way Google was building Android. And Oracle's also tried to take a shot at that, which is tough to do, actually, because they had Schwartz on the stand.
So are you saying that, like, in the original, they were like, it's fine, but then some lawyers came in and said, actually, you could make a lot of money by, arguing this? Like, originally, then Sun was fine with it, and then now they're not, and then that's part of the issue?
And then here we are.
Right. So it's sort of easier for me. That is Google's point of view. It's actually easier to understand this case a bit by understanding Google's narrative first. Google's narrative is, we built Android the right way. We didn't, the Java language was free and open to use. We tried to do a deal with Sun. This is undisputed. They did try to do a deal with Sun that would have allowed them to use Sun implementing code and use Sun's logos and say, kind of powered by Java or something like that when they built Android. But that deal didn't come together. So that deal fell apart in about 2006. And we've seen a lot of emails about that. What Google says is, well, that deal didn't work out, but the Java language was free to use, and we built Android, from scratch, our own engineers, and we also called certain Java APIs, which everyone thought was allowed. And that only became a bad thing once Larry Ellison bought Sun, Oracle bought Sun, tried to get in the smartphone market on their own using Java, wasn't able to do it, and then decided to sue Google. That's Google's narrative. And Oracle has tried to refute that. Oracle's CEO specifically said on the stand, her own lawyer asked her, did you buy Sun to file this lawsuit? And she said no. So the fact that they had to respond to that was kind of interesting in that, that was almost an issue where they were a bit on the defensive. But Oracle's narrative is, you guys actually knew about licensing. You knew you should have paid for Java. look at all these other companies that paid to use Java, and Google is a special company that doesn't believe it should play by the rules.
This story's been interesting because on one hand, you realize the amount of money that's at stake, kind of the players that are involved. Google's Android is no slouch. It makes an insane amount of money and has an insane amount of users. So there's a lot at stake on the company side of things. But I think the bigger picture is that the influence that a case like this has over the smartphone industry in general. I mean, what can you tell us about that? Like, if Google is is ruled as guilty as charged in these regards, sure, they're going to pay a penalty monetarily. But how does that ripple out potentially and affect all the other players in the industry?
Well, I think Google will pay a penalty, and by the way, if Oracle wins, there's going to be a separate damages phase. So this trial won't be over if Oracle wins. They've sort of separated the liability phase and the damages phase in this case, which is an interesting thing. I think the way that it will have a broader effect is that because of the Federal Circuit ruling, risk has already increased for developers. Because you can't really be 100% sure that if you call APIs without the permission of relevant IP owners, that couldn't result in a lawsuit, even a lawsuit years down the line. So in that sense, we would say, maybe the damage has already been done on that front. Mm-hmm. Now, if this case ends with a large penalty against Google, then that'll be an additional element ramping up the risk for developers in the future, in the sense that, we're already in the situation where if you're calling an API without the relevant set of permissions, you might need to have a conversation with a lawyer. If Oracle wins big, well, maybe those same developers will be in a position where you need to have a conversation with the lawyer, and the lawyer will say, look, if you do this, the truth is you might get sued out of existence, because Google might have $7 billion in the bank to pay a large penalty to Oracle. But not many other companies are in that position. Mm-hmm. So if we see that amount of risk out there, that could inhibit future projects for other companies, I think.
So what you're saying, like in the you write that in the economics of software creation, the damage has probably already been done for independent developers.
Yeah, I mean, in terms of legal precedent, it's been set. Now, bear in mind, this case is kind of unusual in that it went to the Federal Circuit. What Google and some organizations that sided with Google, they asked for the Supreme Court to take the case because in their view, it's actually unsettled law. In their view, the Federal Circuit decision conflicts with decisions out of the Ninth Circuit. But the Supreme Court didn't take the case. So, now you're also, and this is all pretty theoretical because, now that decision has been in effect for 2 years and the sky has not fallen on the one hand. On the other hand, we don't really know what's been happening behind the scenes in terms of, because it's not like software programmers having a conversation with their lawyers about how to reduce the legal risk associated with a new product. It's not like they're calling, me, mm-hmm. Or talking to anyone. Those discussions happen in private. But it's an interesting quirk of this case that the whole reason it ended up at the Federal Circuit is because it originally included a patent claim. And that's the only reason it went to the Federal Circuit. All patent cases go to the Federal Circuit. So in a way, there's kind of this odd incentive now where if you have a copyright dispute with someone, certainly one that involves APIs or maybe just one in general, you're almost incentivized to include a patent claim in the lawsuit if you can, because right now the Federal Circuit looks like a pretty good place to end up if you have a novel kind of copyright claim. So, it hasn't happened yet, but you could say that Oracle has kind of laid out a path of how to win a case in a certain way. You can certainly choose your own appeals court.
Yeah, definitely setting a precedent. Not to mention having a jury filled with people who marginally kind of understand, the terminology of the technology going into it. That doesn't hurt a whole lot either.
Yeah.
Joe, it's a pleasure getting you on the show and taking time out of your busy schedule, because I know you've been following this case in the courtroom closely. So we really appreciate you coming on and sharing your insight. Joe Mullen, tell people where they can follow all your work online and find you.
Sure. You can go to arstechnica.com and search for the first story with my name. And when you click on any of our stories from Oracle v. Google, we're including links to all the past coverage in them. So if you're interested in playing catch up, it is possible to do, and there should be a verdict in the next few days.
Excellent.
Thanks,
Excellent.
Joe.
We'll look forward to that. Thank you again, Joe. We'll talk to you soon.
Okay, thanks a lot. It was fun joining you guys.
All right. Have a good night.